You are on HOA nuisance files. I stayed calm and let her talk. I live in Bangor, Maine, and I deliver packages for a living. I moved here 3 years ago for a route job that promised stability after bouncing between gig work in Portland, and the Cypress Point Design Review Association seemed like a normal suburban HOA when I signed the closing papers. The neighborhood is clean, the streets are wide, and the rules looked standard until someone decided a missing survey stake was worth starting a war over. I am on probation at a new job and I cannot miss work for HOA hearings, so when the first notice appeared on my door, I knew I had to handle it fast and handle it right. The trouble started when I installed a new lock on my back gate. It was a simple deadbolt replacement because the old one rusted through, and I thought nothing of it until Janice Clark showed up on my driveway with a clipboard, a megaphone, and a look that said she had been waiting for this moment her entire tenure as safety committee chair. She is a middle-aged woman with dark brown shoulder-length wavy hair, always wearing a white cardigan even in summer, and she treats HOA enforcement like a blood sport. She calls herself the eyes of the neighborhood, and she uses security as an excuse to harass anyone who does not bend to her schedule. Janice was standing at the edge of my driveway when I pulled in after my shift, her white bucket hat tilted back, orange cones arranged in a tight line blocking my path to the garage. She had a tape measure stretched tight along a string line that ran from my fence post to a stake in the ground, and she was shouting before I even turned off the engine. Your new lock violates emergency access requirements under Section 12-4, she said, her voice crackling through the megaphone even though I was 10 feet away. You have 72 hours to remove it or face a $500 fine per day. And I have all day, and so does my fine meter. I got out slowly, keeping my hands visible, because I knew she was recording. I asked her to show me the section she was citing, and she waved a printed packet in my face, pages flapping in the wind. She said the lock created a delay for emergency responders, and that any barrier requiring a key or combination was a violation of the community safety plan. I pointed out that the old lock was also a deadbolt, and no one had ever complained. But she cut me off and said the old lock was grandfathered in, and this was a new installation, which triggered a design review requirement I had failed to submit. I felt my chest tighten because I have a flight early tomorrow and I cannot risk being blocked in my driveway, and I knew this was not about the lock. This was about Janice flexing her authority, and she was using the fence as the excuse because fence violations are her specialty. She had been quiet for months after the last election, but now she was back with a new angle, and she was moving fast. She said the violation extended beyond the lock because my fence itself was under review for setback compliance, and she had received complaints from neighbors about the height and the finish. I asked which neighbors, and she said she was not required to disclose that information, but the complaints were documented and time-stamped. She said the association was freezing my amenities access until I came into compliance, and that meant no pool, no clubhouse, no guest parking passes, and no package delivery to the front office. I kept my voice calm and asked her to put the lock complaint in writing so I could respond through the proper channels. And she laughed and said she already had. She pulled out a plastic evidence bag and showed me a broken survey stake inside, dirt still clinging to the base. She said this was proof that I had disturbed the boundary markers during the fence installation, and that triggered a full property line audit under the design review charter. She said the audit would cost me $2,000 if the findings went against me, and the board had already voted to move forward. I did not touch that stake, I said, and she said it did not matter because the disturbance happened on my side of the line, and I was responsible for all activity within my property boundaries. She said the fence crew I hired had failed to verify the markers before digging, and that made me liable for the correction work and the resurvey. She said the resurvey alone would cost $1,500, and I would have to pay for it up front before the board would consider lifting the amenities freeze. I checked my watch because I had 3 hours before I needed to be at the airport, and I could feel the deadline pressing down on my shoulders. I told her I would review the covenant language and respond in writing, and she said that was fine, but the clock was already running on the lock fine, and every day I delayed was another $500 added to my account balance. She said the association had the authority to place a lien on my property if the balance went unpaid for more than 90 days, and she had seen it happen before. She walked back to her car, leaving the orange cones in place, and I watched her drive away slowly. Her brake lights flashing every few seconds like she was daring me to move the cones before she was out of sight. I waited until she turned the corner, then I moved the cones to the curb and went inside to read the covenant. The packet she had waved at me was sitting on my doorstep, tucked under a rock. It was 30 pages long, printed on cheap paper, and the section she cited was highlighted in yellow with handwritten notes in the margins. The language was vague and contradictory, referencing emergency access standards that were not defined anywhere else in the document, and the design review process she mentioned required a 14-day notice period that she had not given me. I took photos of every page, including the notes, because I knew this was going to escalate and I needed proof of what she claimed, versus what the rules actually said. I called my neighbor, a guy named Tom who sits near the front at meetings and records everything on his phone. He has been through 2 separate HOA fights himself, and he knows the covenant language better than most of the board members. I asked him if he had heard anything about a fence audit, and he said Janice had been asking questions about my property at the last meeting, but the board had not voted on anything publicly. He said she was operating outside the normal process, which meant she was either bluffing or she had convinced the board president to fast-track something off the record. Tom said he would pull the meeting minutes and send me anything relevant, and he warned me that Janice had been using amenities lockouts as punishment for months. He said she had frozen 3 other homeowners in the past year, all of them over minor violations that were later overturned. But by the time they got relief, the damage was done. He said the management company was scared of her because she threatened to sue them for negligence if they did not enforce her complaints, and the board president was too tired to fight her after the last recall attempt failed. I hung up and started drafting a response letter, keeping it short and factual. I stated that I had not been given the required 14-day notice, that the lock was a like-for-like replacement and not a new installation, and that I had not disturbed any survey stakes. I attached the photos of the highlighted packet and requested a copy of the complaint documentation and the board vote authorizing the audit. I sent it to the management company with Tom copied, and I set a reminder to follow up if I did not hear back within 48 hours. Then I went outside and checked the fence line. The string line Janice had set up was still there, stretched tight between a post and a stake about 15 feet into my yard. The tape measure was lying on the ground beside it, the metal tab bent. I took photos of the setup, including close-ups of the stake placement and the string tension, because I knew she was going to claim I had moved something or tampered with her evidence. The next morning I caught my flight, and by the time I landed and turned my phone back on, I had 6 missed calls from the management company and 2 voicemails from Janice. The first voicemail said the board had scheduled an emergency hearing for the following week and my attendance was mandatory. The second voicemail said a tow company had been dispatched to remove my vehicle from the driveway because I had failed to respond to the lock violation within the 72-hour window, and we can tow first and explain later. That is how enforcement works. I called the management company immediately, and the woman who answered said she had been trying to reach me because Janice had filed a second complaint claiming I had blocked emergency vehicle access by parking in my own driveway. She said the tow authorization had been signed by the board president that morning, and the truck was already en route. I told her I was out of town and my car was legally parked in my assigned space, and she said it did not matter because the board had determined that the driveway was part of the violation zone, and any vehicle present was subject to removal. I asked her who signed off on that determination, and she hesitated, then said it was Janice acting as safety chair with board president approval. I told her that was not a valid process under the covenant and I was documenting everything, and she said she understood, but her hands were tied unless I could provide proof that I was not in violation. I asked her what proof she needed, and she said a letter from a licensed surveyor confirming that my fence and gate were compliant with the recorded plat and the setback requirements. I hung up and called Tom, and he said he had just seen the tow truck pull into the neighborhood. He said he was heading over to my house to take photos and video, and he told me not to worry because the truck driver would not touch the car if there was a witness present. He said Janice had tried this before with another homeowner, and the driver had refused to proceed once he realized the board authorization was questionable. Tom called me back 10 minutes later and said the driver had left without towing the car. He said Janice had showed up and tried to pressure the driver to proceed. But the driver said he needed to see a signed authorization from the registered owner or a court order, and Janice could not produce either. Tom said she had threatened to report the driver to his company, and the driver had told her to go ahead because he was not risking his license over an HOA dispute. Tom said Janice had stood in the driveway for another 20 minutes, taking photos of my car and the gate, and then she had left. I thanked Tom and told him I would be back the next day, and I started looking for a surveyor. I found a company in Bangor that specialized in boundary disputes, and I booked an appointment for the day after I returned. The surveyor said he could have a report ready within a week if I provided the plat map and the original fence permit, and I told him I would get him everything he needed. When I got back to Bangor, I went straight to the county records office and pulled the plat map for my property. The setback line was clearly marked, and my fence was 3 feet inside the line, which meant it was compliant. I also pulled the permit history, and I found the original fence permit from 2 years ago, signed off by the city inspector with no violations noted. I made copies of everything and sent them to the surveyor, and then I went home to deal with Janice. She was waiting for me when I pulled into the driveway, orange cones back in place, and this time she had a second plastic evidence bag with another broken survey stake inside. She said the stakes were being systematically removed, and she had documented 3 separate incidents of tampering in the past week. I told her I had not touched the stakes and I had been out of town, and she said that did not matter because the tampering was happening on my property and I was responsible for securing the boundary markers. She said the board had voted to impose a stop work order on any further fence activity until the audit was complete, and that included repairs, painting, and gate maintenance. She said if I violated the stop work order, the fines would increase to $1,000 per day, and the association would seek a court injunction to force compliance. She said I had 72 hours to provide proof that I had not disturbed the stakes, or the board would move forward with the audit and bill me for the costs. I kept my hands open and my voice calm, because the real move was still ahead. I told her I had already hired a surveyor and I would have a full boundary report within the week, and she said that was not good enough because the board required an association-approved surveyor, not a private contractor. I asked her to show me the covenant section that required board approval for private surveys, and she said it was implied under the Design Review Authority, and the board had the discretion to reject any report that did not meet their standards. I told her I would see her at the hearing, and she smiled and said she was looking forward to it. She said she had been documenting my non-compliance for months, and she had a file 2 inches thick with photos, timestamps, and witness statements. She said the board had already decided to move forward with enforcement, and the hearing was just a formality to satisfy the notice requirements. She said I could bring a lawyer if I wanted, but it would not change the outcome, and I would still be responsible for the costs. She left the cones in place again, and I moved them after she drove away. I went inside and called Tom, and I told him I needed his help at the hearing. He said he would be there, and he told me to bring every piece of documentation I had. because Janice was going to try to bury me in procedure, and the board would back her unless I could prove she was operating outside the covenant. The surveyor called me 3 days later and said his crew had completed the fieldwork. He said my fence was fully compliant with the recorded plat, and the setback was clearly marked with iron pins that had been in place since the original subdivision was platted in the 1990s. He said the stakes Janice was claiming as evidence were not original survey markers. They were temporary construction stakes that someone had placed recently, and they had no legal bearing on the boundary line. He said he would have a written report with photos and measurements ready by the end of the week, and he warned me that HOA disputes over property lines usually escalated into litigation if the board refused to accept independent verification. I thanked him and told him to send the report as soon as it was ready, and I started preparing for the hearing. I printed copies of the covenant sections Janice had cited, and I highlighted every contradiction and every procedural requirement she had ignored. I printed copies of the plat map, the fence permit, and the surveyor's preliminary findings. I made a timeline of every interaction with Janice, including the tow attempt and the amenities freeze, and I cross-referenced each event with the covenant process requirements. Tom called me the night before the hearing and said he had pulled the meeting minutes from the past 6 months. He said there was no record of a board vote authorizing the fence audit, and the only mention of my property was a complaint filed by Janice in her capacity as safety chair. He said the board president had acknowledged the complaint, but had not called for a vote, which meant Janice was acting on her own authority and using her position to bypass the normal process. He said that was a direct violation of the management charter, and it gave me grounds to challenge the entire enforcement action. The hearing was scheduled for 7 in the evening at the clubhouse, and I arrived early to set up. Tom was already there, sitting in the front row with his phone and a notebook. Janice was sitting at the board table with the president and 2 other board members, and she had a stack of binders in front of her, each one labeled with a different property address. She saw me come in and smiled, and she said she was glad I had decided to attend because it would save the board the trouble of proceeding in absentia. The president called the meeting to order, and he said the first item on the agenda was a compliance hearing for my property regarding fence violations and emergency access non-compliance. He said the board had received a complaint from the safety chair, and they had reviewed the documentation and determined that a hearing was warranted. He asked Janice to present the complaint, and she stood up and opened one of the binders. She said my property had been under observation for 3 months, and she had documented multiple violations including an unauthorized gate lock, a fence setback encroachment, and systematic tampering with boundary markers. She said the violations posed a safety risk to the community, and the board had the authority to impose immediate fines and corrective action. She said she had photos, timestamps, and witness statements, and she had prepared a full report for the board's review. She started flipping through the binder, and I watched the pages carefully. Most of them were photos of my fence and gate, taken from different angles with handwritten notes in the margins. Some of the photos showed the string line and the tape measure, and a few showed the plastic evidence bags with the broken stakes. She said the stakes had been removed on 3 separate occasions, and she had documented each incident with photos and GPS coordinates. She said the tampering was deliberate and ongoing, and it demonstrated a pattern of non-compliance that justified escalated enforcement. I waited for her to finish, and then I stood up and asked the president if I could respond. He said I would have an opportunity to speak after the board had reviewed the complaint, but I could ask clarifying questions if I had any. I asked Janice to show me the covenant section that required board approval for a private gate lock, and she said it was Section 12-4, which governed emergency access. I asked her to read the section out loud, and she hesitated, then said the section required that all entry points remain accessible to emergency personnel without delay or obstruction. I pulled out my copy of the covenant and flipped to Section 12-4. I read it out loud, and the language was completely different. The section said that all exterior gates must remain unlocked during daylight hours unless the homeowner was present on the property, and it made no mention of lock types or emergency access. I asked Janice where she had gotten her version of the covenant, and she said she was reading from the updated design review guidelines, which superseded the original covenant. I asked the president if the design review guidelines had been formally adopted by the board, and he said he would have to check the records. Janice interrupted and said the guidelines had been in effect for 2 years, and every homeowner had been notified by mail. I said I had never received a notification, and Tom stood up and said he had never received one either. Janice said the notifications had been sent to the addresses on file, and if we had not received them, it was because we had failed to update our contact information with the management company. The president asked the management company representative if she could confirm the notification, and she said she would have to pull the mailing records. Janice said the mailing records were not relevant because the guidelines had been posted on the association website and included in the annual meeting packet. I asked her to show me the website posting, and she said the website had been updated recently and the old postings were no longer available. I turned to the board and said I had hired a licensed surveyor to verify the fence setback, and his preliminary findings showed that my fence was fully compliant with the recorded plat. I said I would provide the full report within 48 hours, and I requested that the board suspend all enforcement actions until the report had been reviewed. Janice said the board could not accept a private survey without verification from an association-approved surveyor, and I asked her to show me the covenant section that required board approval. She could not. She flipped through the binder, muttering about procedure and design authority, and the board president leaned forward and said he was not aware of any requirement for board-approved surveyors. He said the covenant allowed homeowners to obtain independent verification of boundary lines, and the board was required to consider any documentation provided by a licensed professional. Janice said the board had the discretion to reject reports that did not meet their standards, and the president said discretion was not the same as a blanket rejection policy. Tom stood up and said he had reviewed the meeting minutes, and there was no record of a board vote authorizing the fence audit or the amenities freeze. He said Janice had been acting outside her authority as safety chair, and the board needed to address the procedural violations before moving forward with enforcement. Janice said she did not need a board vote to file a complaint, and the safety chair had independent authority to impose interim restrictions pending a hearing. The president asked the management company representative if that was correct, and she said the safety chair could file complaints, but could not impose fines or freeze amenities without a board vote. She said the amenities freeze on my account had been entered manually by Janice using her administrative access, and it had not been authorized by the board. The president looked at Janice and asked her to explain, and she said she had acted in the interest of community safety, and she had planned to seek board ratification at the next meeting. The room went quiet. One of the other board members, a woman in her 60s, said she had not been informed of any amenities freeze, and she was uncomfortable with the safety chair imposing penalties without board oversight. The president said he agreed, and he instructed the management company to lift the freeze immediately. Janice said the freeze was necessary to ensure compliance, and the president said it was not her decision to make. I asked the president if I could present my evidence, and he said I could. I walked up to the board table and handed out copies of the plat map, the fence permit, and the surveyor's preliminary findings. I explained that the stakes Janice had been using as evidence were not original survey markers, and the actual boundary was marked with iron pins that had been in place for decades. I said the surveyor had confirmed that my fence was 3 feet inside the setback line, which meant it was fully compliant, and Janice's entire complaint was based on temporary construction stakes that had no legal bearing. Janice stood up and said the stakes were placed by a professional crew, and they had been used to verify the boundary during a previous dispute. I asked her when the stakes had been placed, and she said she did not have the exact date, but it was within the past year. I asked her if she had documentation showing who placed the stakes and why, and she said the documentation was in her files at home and she had not brought it to the meeting. If you are enjoying this HOA chaos, hit the like button and subscribe for more stories where the rules backfire on the people who weaponize them. The president said he needed to see the documentation before the board could move forward, and he asked Janice to provide it within 7 days. Janice said she would, but she insisted that the stop work order remain in place until the audit was complete. The president said he was not comfortable imposing a stop work order without clear evidence of a violation, and he instructed the management company to suspend all enforcement actions pending review of the survey report. Janice's face went red. She said the board was ignoring the safety implications, and she warned them that they would be liable if emergency personnel were unable to access the property. The president said the liability concern was noted, but the board had a duty to follow the covenant process, and rushing to enforce without proper documentation was a bigger risk than waiting for verification. The meeting ended 20 minutes later, and Janice left without speaking to anyone. Tom and I stayed behind to talk to the president, and he apologized for the confusion. He said Janice had been overstepping her authority for months, and the board had been trying to rein her in without triggering a full recall fight. He said my case had finally forced the issue, and the board was going to review the safety chair's administrative access and the enforcement procedures. I thanked him and told him I would send the full survey report as soon as it was ready. Tom and I walked out to the parking lot, and he said Janice was not going to let this go. He said she had a history of escalating when she did not get her way, and I should expect her to file additional complaints or try to bypass the board again. He said the best defense was to stay ahead of her with documentation and witnesses, and to make sure every interaction was recorded. He was right. 2 days later, Janice showed up at my house with a fence crew in tow. She said the board had authorized an emergency inspection, and the crew needed access to my backyard to verify the boundary markers. I asked her to show me the board authorization, and she said it was verbal and she had confirmed it with the president that morning. I called the president on speaker, and he said he had not authorized any inspection, and Janice was acting on her own again. The crew heard the call and started packing up their tools. The foreman said he was not going to proceed without written authorization, and he told Janice he would need to see a signed board resolution before he came back. Janice tried to argue, but the foreman cut her off and said his company had been burned by HOA disputes before, and he was not risking his license. He said if she wanted to inspect the fence, she needed to go through the proper channels and get a court order. Janice left, and I sent the president an email summarizing what had happened. He replied within an hour and said the board was scheduling an emergency executive session to discuss Janice's conduct, and he asked me to provide a written statement with dates and details. I spent the evening drafting the statement, and I included every interaction, every procedural violation, and every piece of evidence I had collected. I attached the photos, the surveyor's preliminary findings, and Tom's meeting minutes analysis. The surveyor sent me the final report 2 days later. It was 12 pages long, with detailed measurements, photos, and a site map showing the iron pins and the setback line. The report confirmed that my fence was fully compliant, and it noted that the temporary stakes Janice had been using were not placed by a licensed surveyor and had no legal bearing on the boundary. The report also included a section on HOA enforcement procedures, warning that boards who relied on inaccurate boundary information could be held liable for damages if homeowners were forced to incur legal costs to defend against baseless complaints. I sent the report to the board, the management company, and Tom. The president replied the next day and said the board had voted to close the complaint and remove all fines and restrictions from my account. He said the board had also voted to suspend Janice's administrative access pending a full review of her conduct, and they were considering a formal reprimand. He said the board wanted to avoid a public fight, but they could not ignore the procedural violations. and they were committed to ensuring that future enforcement actions followed the covenant process. I thought it was over, but Janice was not done. She filed a secondary complaint with the management company, claiming that my fence crew had damaged her property during the installation, and she was seeking reimbursement for repairs. She said the damage included a cracked driveway, a broken sprinkler head, and trampled landscaping, and she was demanding $2,000 in compensation. She said if I did not pay voluntarily, she would file a claim with the association's dispute resolution process and seek a lien on my property. I called the fence contractor and asked him if there had been any incidents during the installation, and he said there had not. He said his crew had been careful to stay within my property boundaries, and they had taken photos before and after the job to document the site conditions. He said he would send me the photos and a written statement confirming that no damage had occurred. The photos showed Janice's driveway before the fence work, and there was already a crack in the concrete near the curb. The sprinkler head she claimed was broken was not visible in the photos, and the landscaping she said was trampled looked the same before and after. I forwarded the photos to the management company with the contractor's statement, and I asked them to close the secondary complaint. Janice responded by filing a third complaint, this time claiming that I had violated the guest parking policy by allowing a contractor truck to park in a guest's spot for more than 4 hours. She said the violation had occurred during the fence installation, and she was demanding a $100 fine per day for each day the truck had been parked in the guest lot. She said the guest parking policy was strictly enforced, and I was responsible for ensuring that my contractors followed the rules. I pulled the guest parking policy from the covenant, and it said guest parking was limited to 72 hours per visit, with no restriction on contractor vehicles. I sent a copy of the policy to the management company and asked them to close the complaint. Janice filed a fourth complaint the next day, claiming that my fence paint color did not match the approved palette, and she demanded that I repaint the fence within 30 days, or face a fine. I was done playing defense. I called a lawyer who specialized in HOA disputes, and I scheduled a consultation. The lawyer reviewed my documentation and said I had a strong case for harassment and abuse of process. He said Janice's pattern of baseless complaints, procedural violations, and retaliation met the legal standard for harassment, and I could file a formal complaint with the board and demand that they take action. He said if the board failed to address the harassment, I could file a lawsuit against the association and Janice personally for damages and attorney fees. He also said I had a trump card that could end the fight immediately. He said the police incident number from Janice's prior trespass attempt on another homeowner's property was public record, and it showed a pattern of overreach and intimidation. He said if I raised the incident number in a formal complaint, it would force the board to confront Janice's history, and it would make it much harder for her to claim she was acting in good faith. He said the key was to deploy the information strategically, at a moment when the board and the community were watching, so the impact would be immediate and undeniable. I thanked the lawyer and paid him for the consultation. I decided to hold the trump card until the next board meeting, because I wanted to see if the board would take action on its own first. If they did not, I would deploy the incident number and force their hand. The board scheduled a special meeting 2 weeks later to address Janice's conduct. The agenda included a review of the safety chair's authority, a discussion of enforcement procedures, and a vote on whether to remove Janice from her position. The meeting was open to the community, and the clubhouse was packed. Tom and I sat in the front row, and Janice sat at the board table with her binders and her orange cones stacked beside her chair. The president opened the meeting and said the board had received multiple complaints about the safety chair's enforcement actions, and they needed to address the concerns before moving forward with any new business. He said the board took the complaints seriously, and they were committed to ensuring that all enforcement actions followed the covenant process and respected homeowners' rights. Janice interrupted and said the complaints were baseless, and she had been doing her job exactly as the board had directed. She said she had been documenting violations, filing complaints, and imposing interim restrictions in accordance with the safety chair's authority, and she had never acted outside her scope. She said the board was caving to pressure from homeowners who did not want to follow the rules, and she warned them that weakening enforcement would lead to chaos and declining property values. The president asked her to address the specific allegations, starting with the amenities freeze on my account. He asked her if she had obtained board approval before entering the freeze, and she said she had not because the freeze was an interim measure pending a hearing. He asked her if she had notified me of the freeze, and she said she had left multiple voicemails and the management company had sent a letter. I stood up and said I had never received a letter, and the voicemails I received were threats, not notifications. Janice said I was lying, and the president told her to sit down. He said the board had reviewed the documentation, and there was no record of a board vote authorizing the freeze, no letter in the management company's files, and no evidence that I had been given proper notice. He said the freeze was a clear procedural violation, and it had caused me financial harm because I had been unable to use the amenities I was paying for. Janice said the harm was minimal, and the freeze had been necessary to ensure compliance. The president said that was not her decision to make, and the board had the sole authority to impose penalties. He said the safety chair's role was to file complaints and provide documentation, not to act as judge and jury. One of the other board members asked Janice about the survey stakes, and she pulled out the plastic evidence bags. She said the stakes had been placed by a professional crew during a previous boundary dispute, and they had been systematically removed after I started my fence project. I asked her to provide documentation showing when the stakes were placed and who placed them, and she said the documentation was in her files and she had not brought it to the meeting. The board member said that was not acceptable, and he asked her to produce the documentation within 48 hours. Janice said she would, but she insisted that the stakes were legitimate markers and my surveyor's report was irrelevant. The board member said the surveyor's report was based on the recorded plat and iron pins that had been in place for decades, and it carried more weight than temporary stakes with no documentation. Tom stood up and said he had reviewed the meeting minutes, and there was no record of any boundary dispute involving my property. He said the only mention of stakes was in Janice's complaints, and there was no evidence that a professional crew had placed them. He said it was more likely that Janice had placed the stakes herself to create evidence for her complaint, and the board needed to investigate. Janice stood up and shouted that Tom was accusing her of fabricating evidence, and she demanded an apology. Tom said he was not accusing her of anything. He was pointing out that the documentation did not exist, and the board had a duty to verify her claims before imposing penalties on homeowners. The president told both of them to sit down, and he said the board would review the evidence and make a determination. That was when I decided to deploy the trump card. I stood up and said I had information that the board needed to consider before making any decisions about Janice's conduct. I said I had obtained a police incident number from a prior trespass attempt involving Janice and another homeowner, and the incident report showed a pattern of overreach and intimidation. I said the report documented that Janice had entered the homeowner's backyard without permission, had refused to leave when asked, and had threatened to call a tow truck if the homeowner did not comply with her demands. The room went silent. Janice's face turned white, and she said the incident was a misunderstanding and had been resolved without charges. I said that might be true, but the incident report was public record, and it showed that this was not the first time she had crossed the line. I drop it in a calm, two-sentence statement, then let the silence do the damage. The police were called because she refused to leave private property after being asked multiple times, and the homeowner filed a formal complaint with the board that was never addressed. The president asked me if I had a copy of the incident report, and I said I did. I handed him a printed copy, and he read it silently while the room waited. When he finished, he set the report on the table and said the board needed to take a recess to discuss the new information. Janice stood up and said the board could not use an old incident to justify removing her from her position. And the president said they were not removing anyone yet. But they needed to understand the full context before making any decisions. The board recessed for 20 minutes, and when they came back, the president said the board had voted to suspend Janice's administrative access and to launch a formal investigation into her conduct as safety chair. He said the investigation would include a review of all complaints filed by Janice, all enforcement actions taken under her authority, and all incidents involving homeowners who had raised concerns about her behavior. He said the board would reconvene in 30 days to review the findings and determine whether further action was warranted. Janice stood up and said the board was making a mistake, and she would not allow them to scapegoat her for doing her job. She said she had been protecting the community from non-compliant homeowners, and the board was caving to pressure from people who wanted to ignore the rules. She said if the board moved forward with the investigation, she would resign and take legal action against the association for defamation and breach of fiduciary duty. The president said that was her choice, but the board had a duty to investigate credible allegations, and they were moving forward. Janice grabbed her binders and walked out, slamming the door behind her. The room erupted in conversation, and several homeowners stood up to thank the board for taking action. Tom leaned over and said Janice had just made a huge mistake by threatening to sue, because it gave the board legal cover to remove her immediately. The board reconvened 2 weeks later, and Janice did not attend. The president said the investigation had found multiple procedural violations, including unauthorized fines, baseless complaints, and abuse of administrative access. He said the board had voted to remove Janice from her position as safety chair, and they were referring the matter to the management company for further review. He said the board was also implementing new procedures to ensure that enforcement actions followed the covenant process, and they were establishing an oversight committee to review complaints before they were filed. The president also said the board had received a resignation letter from Janice, effective immediately. He said the resignation did not end the investigation, and the board was considering whether to pursue reimbursement for homeowners who had been charged improper fines or forced to incur legal costs to defend against baseless complaints. He said the board was committed to restoring trust in the association, and they were open to input from the community on how to improve the enforcement process. That same week, I received a letter from the management company. The letter said the board had voted to close all complaints related to my property, and they were issuing a full refund of the fines that had been charged to my account. The letter also included a written apology for the procedural violations and the amenities freeze, and it confirmed that my account was in good standing, with no restrictions. The refund check arrived 3 days later, along with a second letter from the board attorney. The letter was short and formal, and it said the association was retracting all allegations related to fence violations, emergency access non-compliance, and boundary marker tampering. The letter also said the association would cover my legal consultation fees, and they were issuing a written warning to the former safety chair for harassment behavior. Tom called me that evening and said the board had scheduled a special meeting to discuss a recall vote for the board president. He said several homeowners had filed a petition claiming the president had enabled Janice's conduct by failing to act sooner, and they wanted new leadership. He said the petition had the required number of signatures, and the meeting was set for the following month. He said it was going to be a long night, but the momentum was on the side of reform, and there was a real chance the board would turn over completely. The recall meeting was packed. Homeowners filled every seat in the clubhouse, and several people stood along the walls. The president opened the meeting and said the board had received the recall petition, and they were prepared to address the concerns. He said the board took responsibility for the failures in oversight, and they were committed to making changes. The petitioners presented their case, and they laid out a timeline of Janice's conduct and the board's inaction. They said the board had received multiple complaints about Janice over the past 2 years, and they had failed to investigate or take disciplinary action. They said the board's failure to act had allowed Janice to target multiple homeowners with baseless complaints, improper fines, and harassment, and the community had lost trust in the leadership. The president defended the board's actions, but his defense was weak. He said the board had been trying to address the issues internally, and they had not wanted to trigger a public fight. He said the board had acted as soon as they had clear evidence of procedural violations, and they had removed Janice from her position and issued refunds to affected homeowners. He said the board was committed to reform, and he asked the community to give them a chance to implement the new oversight procedures. The petitioners were not satisfied. They called for an immediate vote, and the room erupted in debate. Several homeowners stood up to support the recall, and a few defended the board. Tom stood up and said the board had lost credibility, and the community needed new leadership to restore trust. He said the recall was not personal, it was about accountability, and the board had failed to hold Janice accountable until the situation became a crisis. The vote was held by secret ballot, and the results were announced 30 minutes later. The recall passed by a margin of 70%, and the board president and 2 other board members resigned immediately. The remaining board members called for a special election to fill the vacant seats, and the election was scheduled for 6 weeks later. The election turned into a referendum on HOA enforcement. Several candidates ran on reform platforms, promising to limit the board's enforcement authority, establish clear procedures for complaints and appeals, and increase transparency in board decisions. Tom ran for a seat, and he won by a wide margin. The new board took office 2 months later, and one of their first actions was to freeze all enforcement actions pending a full review of the covenant and the design review guidelines. The new board also voted to suspend the amenities lockout policy, and they established a dispute resolution committee to mediate conflicts before they escalated to fines or hearings. They hired a new management company that specialized in covenant compliance and homeowner rights, and they required the new company to implement a tracking system for complaints, fines, and enforcement actions. Janice never came back to a board meeting. I heard from Tom that she had moved out of the neighborhood a few months after the recall, and she had sold her house at a loss because the market was slow. He said the new owners were quiet and friendly, and they had no interest in HOA politics. The fence stayed up, and I never heard another word about setback violations or emergency access. The surveyor's report became part of the association's permanent records, and the new board used it as a reference for future boundary disputes. Tom told me that 3 other homeowners had filed complaints against Janice after the recall, and the new board had issued formal apologies and refunds in each case. One of the funniest moments came a few months after the recall. I was at the gas station lot at the edge of the subdivision, filling up before a delivery shift when I saw Janice's car pull in. She parked at the far end of the lot, away from the pumps, and she got out with a stack of papers in her hand. I recognized the papers immediately. They were the same printed packets she had used to threaten me, and she was walking toward a group of homeowners who were standing near the convenience store entrance. I could not hear what she was saying, but I could see her gesturing at the papers and pointing back toward the neighborhood. The homeowners looked confused, and one of them shook his head and walked away. Janice followed him, still talking, and that was when the wind picked up. A strong gust came through the lot, and Karen's printed packet went airborne in a gust of wind at the worst possible moment. Pages scattered across the asphalt, tumbling into puddles and under parked cars, and Janice scrambled to chase them down. She managed to grab a few pages, but most of them blew into the drainage grate near the edge of the lot. She stood there for a moment, staring at the grate, and then she got back in her car and drove away. I finished filling up and drove off, and I could not stop smiling for the rest of my shift. The final piece of closure came 6 months later, when I received a letter from a lawyer representing the association. A lawyer letter that forces a retraction and a refund arrived in my mailbox, and it formally retracted all allegations related to my fence, issued a check for the full refund amount, and included an apology signed by the new board president. The letter also confirmed that the HOA freezes enforcement pending a policy rewrite, and no new complaints would be filed until the revised procedures were approved by the membership. The letter included a second page with a written warning for harassment behavior that had been issued to Janice. The warning stated that she was prohibited from filing any future complaints without board pre-approval, and any violation of the prohibition would result in a formal hearing and potential expulsion from the association. The warning also noted that the police incident number I had raised was part of her permanent record with the association, and it would be disclosed to future boards and management companies as part of any background review. Tom called me after he saw the letter, and he said the board had voted to send similar letters to every homeowner who had been targeted by Janice. He said the board wanted to close the chapter and move forward, and they were committed to making sure the enforcement process was fair and transparent. He said the new oversight committee had already reviewed and dismissed a dozen baseless complaints that had been filed by Janice before her removal, and they were working on a revised covenant that would limit the board's authority to impose fines without a hearing. I kept the letter and the check in a folder with the rest of my documentation, and I filed it away in case I ever needed it again. I also kept the plastic evidence bag with the broken survey stake that Tom had saved from the board meeting. He gave it to me as a joke, and I keep it on a shelf in my garage as a reminder that even the most absurd HOA fights can be won if you document everything and stay one step ahead. The neighborhood settled into a new rhythm after the recall. The new board held quarterly town halls to update the community on covenant revisions, budget decisions, and enforcement actions. They published a monthly newsletter with transparent reporting on fines, complaints, and dispute resolutions. They also established a homeowner advisory committee that reviewed all proposed rule changes before they went to a vote, and they required the board to justify any enforcement action with clear evidence and proper notice. Tom became the new safety chair, and his approach was the opposite of Janice's. He focused on education and mediation instead of fines and threats. He organized workshops on covenant compliance, property maintenance, and dispute resolution, and he worked with homeowners to address issues before they escalated to complaints. He also implemented a public database of enforcement actions, so homeowners could see how the rules were being applied and challenge inconsistencies. The neighborhood is not perfect, but it is better. The new board is not afraid to admit mistakes, and they are willing to listen when homeowners raise concerns. The enforcement process is slower, but it is fairer, and most disputes are resolved through mediation instead of hearings. The clubhouse is no longer a battleground, and the meetings are shorter and less contentious. I still deliver packages for a living, and I still check my watch constantly because of deadlines. I still have the same fence, the same gate, and the same lock. The string line is gone, the orange cones are gone, and the plastic evidence bags are gone. The only thing that remains from the fight is the surveyor's report, filed with the association and the county, proving once and for all that my fence was never a violation. Every time I pull into my driveway, I think about the moment Janice stood there with her megaphone and her tape measure. So sure she had me cornered. I think about the tow truck that never touched my car, the board meeting where the silence did the damage, and the gas station lot where her papers scattered in the wind. I think about the lawyer letter, the refund check, and the written warning that ended her reign. I kept my hands open and my voice calm, because the real move was still ahead, and when the moment came, I was ready. Thanks for watching, and I will catch you in the next one.